Hi, everybody. A very warm welcome to Thorough Newspaper Analysis for the 28th of March 2024. Now, let's quickly head to the agenda for today. And first of all, we have the editorial segment. Here, we have an Indian Express article with the title, Why did the Supreme Court allow Bloomberg's article against Z to remain online? So, this is a very important article because here, today, we'll understand two concepts. One is the concept of a slap suit. And secondly, what is the three-pronged test that a court has to employ while dealing with pre-trial injunctions? This is going to help you, especially with your SRA and subjects where you study the concept of injunction. Secondly, we talk about the news updates for the day, and this is going to be followed by the last segment where we have a look at the legal news. So let's start with the context of this entire article first. See, a Supreme Court has overruled a trial judge's order directing Bloomberg to take down its article on SEBI's investigation into Z. So I'll give you a context and storyline just shortly. Okay, so what has happened here? Supreme Court ने trial judge के एक order को overrule किया है. Trial judge का order क्या था? Trial judge directed a journalist or a media platform called Bloomberg कि you take down an article that you wrote on investigation conducted by SEBI into the accounts and affairs of Z, which is Z Entertainment Enterprises. अब व्हाट इज दिस एंटायर मैटर? क्या वो आर्टिकल था? कैसे ट्रायल जज ने क्या बोला? हाई कोर्ट ने क्या बोला? देन सुप्रीम कोर्ट के पास मैटर कैसे आया? लेट्स अंडरस्टैंड दैट. ओके, सो होता ये है कि 21st February को देयर इज दिस आर्टिकल व्हिच इज पब्लिश्ड बाय ब्लूमबर्ग विद द टाइटल इंडिया रेगुलेटर फाइंस $241 million अकाउंटिंग इशू एट Z. इस आर्टिकल में ये बताया गया कि सिक्योरिटीज एंड एक्सचेंज बोर्ड ऑफ इंडिया, व्हिच इज पॉपुलरली कॉल्ड द SEBI, it had conducted an investigation into accounts of Z. And उस investigation में उनको ये पता चला that there is a whole of more than $240 million in the accounts of Z. And this amount, the report stated, it was diverted illegally and it is 10 times higher than what the investigator, SEBI, it initially had estimated. So this is the entire matter. अब इससे होता क्या है? Z got triggered and as a result, it initiated a defamation proceeding. अब defamation proceeding का वो ground क्या था? So as per Z, this article was published to malign the entertainment giant, to rupture its reputation. And Z claimed that this article, it presented speculation on the business operations of Z as truth, कि speculations को truth बनाया गया है, and that the allegations of illegal fund diversion, it did not have any basis whatsoever. It was further claimed by the plaintiff, जिन्होंने suit file किया है, Z, that following the publication of this article, its stock price fell by roughly 15%. As a result, it resulted in economic suffering on part of the company and its investors. So on these grounds, before the defamation trial could even begin, Z requested the court to direct Bloomberg to take down the article. तो यहाँ पर हुआ क्या? Article got published, defamation suit got filed, and defamation suit की trial शुरू होने से पहले Z sought that the court that you sought from the court that you may kindly please direct the defendant to take down this article. Now on 1st of March, the trial judge, he ruled in favor of Z and directed Bloomberg to take this article down. Now on 14th of March, the Delhi High Court was approached by was approached by Bloomberg, and on 14th of March, the Delhi High Court also upheld the trial judge's order, and as a result, Bloomberg had to approach the Supreme Court. Supreme Court के सामने क्या हुआ? As we just saw in the beginning of this article, Supreme Court overturned the decision of the trial judge. So the Supreme Court had now directed the trial judge to pass fresh orders, keeping in mind their observation about slap suits and the factors to consider before granting a pre-trial injunction. तो अब हम बात करेंगे कि सुप्रीम कोर्ट ने आखिर क्या ऑब्जर्वेशंस करी after about pre-trial injunction and the test to be followed and the concept of slap suits. So let's first go to the pre-trial injunctions concept. The apex court highlighted the three-pronged test which is used by the trial judge in its order. Now, what is that three-pronged test? I'm going to list out those tests and then we're going to understand. First, there should be a prima facie case which justify the injunction order. Secondly, there must be an irreparable loss and injury which may result if injunction is not granted to the person seeking such injunction. Thirdly, balance of convenience, it is in favor of the parties seeking such injunction. Now let's discuss these. So the trial court judge on 1st March had observed that there was a prima facie case to justify an injunction against Bloomberg. Correct? So first test met. ट्रायल कोर्ट ने ये ऑब्जर्व किया कि हाँ एक प्राइमा फेसी ऑन द फेस ऑफ इट केस तो है जो कि जस्टिफाई कर रहा है कि अगर हम इंजंक्शन ऑर्डर दें अगेंस्ट ब्लूमबर्ग तो दैट वुड बी justified. Secondly, that Z might suffer irreparable loss and injury if there is no injunction. And thirdly, the balance of convenience was in favor of Z. What does it mean, balance of convenience? It implies that more harm would be caused to Z if injunction was not granted than the harm that would be caused to Bloomberg if the injunction was granted. तो नुकसान तो दोनों को होगा, पर ज्यादा नुकसान किसको होगा? क्या करने से ज्यादा नुकसान होगा? ज्यादा नुकसान ट्रायल कोर्ट के हिसाब से जी को होगा अगर हम इंजंक्शन ना ग्रांट करें, तो इसलिए इंजंक्शन वाज ग्रांटेड. नाउ सी, सुप्रीम कोर्ट ने दो बातें बोली. एक तो कि यस वी डू अग्री दैट दिस इज द एस्टैब्लिश्ड लॉ. This is the established three-pronged test that we do for pre-trial injunctions. That's fine. But the manner in which the trial judge applied this test did not, set well with the Supreme Court. So the Supreme Court held that the test cannot be applied very mechanically and that the court must provide detailed reasons to justify how each prong of this test is satisfied before ordering a pre-trial injunction. What is a pre-trial injunction? A direction to the parties to perform certain actions before the trial begins. The order of trial judge, the Supreme Court held, it suffers from such mechanical applications without reasons being furnished. The apex court also held that there are additional factors that judges must consider when considering pre-trial injunctions, and more so when these injunctions are issued against journalists and persons of civil society, that is to say NGOs and researchers. So specifically in cases where media platforms and journalists have been accused of defamation, the court held that a balance must be struck between the right to free speech and the right to reputation. यही तो दो conflicting interest होते हैं ना defamation suit में. One entity is saying that I have right to speech and therefore I said so and so, and the other person वो क्या बोलेंगे that my reputation has been compromised because of that. So Supreme Court ने ये बोला है कि that you have to balance these conflicting interests also. The court also observed that the High Court should have intervened after considering the impact of injunction on the constitutionally protected right of free speech. Now let's talk about SLAP suit. See, SLAP suit, this acronym, it stands for Strategic Litigation Against Public Participation. By this very name also, I'm sure हम समझ गए होंगे कि what is a SLAP suit. Consider this scenario. एक कोई बहुत ही ऐसी entity है which has economic prowess and it is a giant company or an MNC, and there is a journalist. The journalist has found some fault with the operations of the company, or let's say with the company's funds management, or with any safety measures that have been compromised in the operation of the firm. So ये कोई भी XYZ reason के कारण the journalist or any member of the civil society, any general public member is questioning the organization or is, putting this information out in the media, and wo jo organization hai is then coming forward with a defamation suit, is then, trying to silence the voice of that other person, that other entity, and is just slapping that person with a suit. So that is a slap suit. It is an umbrella term which is used to refer to litigations predominantly initiated by entities that yield immense economic power against members of the media or civil society. And इनका purpose क्या होता है? To prevent the public from knowing about or participating in important affairs of public interest. अब ये slap suit जो term है, how was it coined? Let's see that. So it was coined by professors George W. Pring and Penelope Cannon from University of Denver, and it happened in 1980s, according to the American Civil Liberties Union website. In 1996, the two professors, they published a book together titled Slaps Getting Sued for Speaking Out. Now, in this particular case, current case, connecting slap suits to pre-trial injunctions, the court noted that such injunctions against journalists and media organizations, it can act as a death sentence to the material which is sought to be published. The Apex Court also stressed that courts must consider that injunctions can be used as an avenue to prolong litigations also to prevent free speech and public participation. This is the Supreme Court's observation on slap suit. Now let's see quickly as to what is the response of international community on slap suits. So some international forums, they've adopted anti-slap laws to protect journalists and media organizations from litigation as a harassment tactic. In February, to give you an example, in February 2024, the European Parliament, it voted in favor of and adopted the anti-slap directive, which EU member states can now adopt and build national legislations around. तो very recently, इसी साल में क्या हुआ था, यूरोपियन पार्लियामेंट ने एक एंटी स्लैप डायरेक्टिव जो है उसको अडॉप्ट किया. अब जो ईयू मेंबर्स हैं उनके पास लिबर्टी है कि वो उस डायरेक्टिव को फाउंडेशन स्टोन मानकर उसके अराउंड खुद के लॉज बना सकते हैं फॉर एंटी स्लैप. The directive provides procedure to dismiss cases at the earlier stage when based on unfounded claims, place costs on litigants who initiate slap proceedings, and provide compensation to the victim of such cases. So that's all we have for this article. I hope you are now, in a position to understand both of these concepts. Now we proceed to the next segment. Now let's proceed to the national news category, and we just have one update here. Climate activist and innovator Sonam Wangchuk, he ends his 21-day hunger strike in Leh. The climate activist and innovator, he was on a hunger strike in Leh in Ladakh. What were his demands? See, essentially, he was demanding statehood for Ladakh and also inclusion of Ladakh in the 6th schedule of the constitution. The Ladakhi activists, they've matched the longest fast held by Mahatma Gandhi during the freedom movement. Security Council demands immediate ceasefire in Gaza. US has abstained from voting. The United Nations Security Council, it has passed a resolution with these three prominent demands. A being immediate ceasefire for the month of Ramadan. Secondly, immediate and unconditional release of hostages. Thirdly, urgent need for demand for expanding the flow of aid into Gaza. There are 14 votes in favor, none against, with one nation abstaining, and that is United States. Hong Kong has regained its spot as the world's 4th largest market following a broad market rout in Indian equities. India also, it has positioned itself as an alternative to China, thereby attracting fresh capital from global investors and companies alike. Simon Harris, he becomes Irish Prime Minister in waiting. So he has become Ireland's Prime Minister in waiting after he was elected unopposed to succeed Leo Varadkar as leader of the governing Fine Gael party. Now, this fact is not mentioned here, but he is one of the youngest to the post of Prime Minister. Gaia telescope, it discovers two ancient streams of stars, Shiva and Shakti. European Space Agency's telescope, it has discovered two ancient streams of stars named Shiva and Shakti. Led by Khyati Malhan of the Max Planck Institute for Astronomy in Germany, this revelation, it enhances our understanding of the Milky Way's origin. So basically, the discovery of both of these streams of stars, this is going to help us in understanding how Milky Way galaxy, which is the home to our planetary system, it origined. Its origin, where does it lie? How did it start? What is the origin point? So we're going to understand, and we're going to enhance our understanding of our galaxy following this discovery. Let's talk about Milky Way galaxy. Now, this is an important point in some of the states where GK is a part of your syllabus. You may expect this question as to what is the shape of Milky Way galaxy, because different galaxies have different shapes. So, our galaxy, the Milky Way galaxy, it is spiral galaxy. It contains our solar system along with billions of other stars. Sun is one of such stars, and along with other planets, asteroids, and other celestial objects. This is also an important update. Carlos Sainz wins Australian Grand Prix. Now we come to the legal updates for today. First of all, we have a Supreme Court update which pertains to the entire concept of examination, examination in chief, cross-examination, and all of these. Examination in chief of witnesses without recording their cross-examination is contrary to law, the Supreme Court has said. Let's see, this is very important for Evidence Act. So the Supreme Court has observed that recording only the examination in chief of witnesses without recording their cross-examination, this is contrary to the law. To strengthen this, the court also referred to Section 138 of the Indian Evidence Act, which outlines the examination order of witnesses. Section 138, if it puts forward as to what is to be conducted first, then what has to follow, then what has to follow. So this provision essentially says that witnesses are to be first examined in chief. So please remember this order. First, there has to be examination in chief. Then if the opposite party wants, there should be cross-examination. And then if the party which is bringing the witness, which is conducting the examination in chief, then that party can re-examine its own witness. So there's examination in chief, followed by cross-examination, and there's re-examination. This order, it is mentioned under Section 138 of the Evidence Act. In this respect, the court also noted that though in warrant cases, cross-examination of witnesses can be postponed, that is also an exception to the ordinary practice of law. It may be noted that a warrant case relates to offences which are punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. This is a question that you often see in your PT exam. What is a summons case? What is a warrants case? So please remember, warrant case is a case which relates to an offense. What is the nature of the offense? It is punishable with a term of imprisonment exceeding 2 years. So it can be any term, 3, 4, 7, 10. It can be life imprisonment or death. And summons case is what? A case other than a warrant case. A case not being a warrant case, which means where offense is punishable, less than 2 years. The name of this case is Akene, Godwin, and another versus State of Tamil Nadu. Another update from the Supreme Court in the case of Puneet Sabarwal versus CBI. So here the Supreme Court in a recent judgment held that exoneration in income tax proceedings by itself would not become a valid ground for the discharge of an accused against the provisions of the Prevention of Corruption Act. So essentially, here the Supreme Court is saying, if let's say A is a person, he was made, the criminal prosecution was initiated against him in under the Income Tax Act, and also under the Prevention of Corruption Act. So if he is exonerated under the IT Act proceeding, then that would by itself not be a valid ground to discharge the accused under the charges which were put forth under the Prevention of Corruption Act. These are independent. The bench also observed order under the Income Tax Act favoring the accused would not be conclusive proof of lawlessness of source of income. Lawfulness, I'm sorry. It would not be a conclusive proof of the source of income being lawful. The court in its decision dwells into the settled position of law which was held in the case of State of Karnataka versus Selvi Jayalalitha and others. To understand the probative nature of such orders passed by the income tax tribunals and the authorities from the lens of criminal prosecution. And this has brought us to an end to our TNA. The link for the quiz based on yesterday's TNA is made available in the description of this video. In case you want to get access to the free study materials or the TNA slides that have been used in this video, please feel free to join our Telegram channel. For that, you may click on the link which is given in the description or scan the barcode here. These are the point of contacts in case you want to get in touch with LawSikho. Thank you for being with us.